Hello and welcome to this episode of the Digi Pod. My name is Farieha Aziz. Today I'm joined by Omar Rajarathnam, who is a co-founder and executive director of Factum, and Ashwini Natesan, who is a legal consultant, and both of them are based in Sri Lanka. Today we're discussing the Online Safety Act. Recently, the government posted a public notice asking for comments, and obviously the OSA, there has been a reform process that is underway. Before we get to that, Omar, if I can first turn to you to maybe contextualize for our audience, right? How did the OSA, what led to its enactment? What was the need felt for it?
Thank you, Faria, for having us on the show. So firstly, I think the Online Safety Act has been in discussion in Sri Lanka at least for the past 7 to 8 years. So it was not something that was newly formed and then, like something that was actually sprung across the Sri Lankan citizens as a surprise. But what really happened was that the previous government, so you also, many also are aware that Sri Lanka had a public uprising in 2022, and then really a public uprising ousted a democratically elected president there. And then we also then had to go in to select a successor via a parliamentary system. And at that time, there were, because of this uncertainty, the political uncertainty that was going on as well, the current government that is now in power, that was elected to power in 2024, was also starting to basically socialize this idea that they really have a very good social media plan going for the elections. And I think the previous government at the time was fairly nervous about it, and was looking to ways to crush that level of political dissent. So by about 2023, we were also having these stories about an Online Safety Act being going to make the rounds again. But by that time in Sri Lanka also, what we had also done as a proactive measure was, in fear of this state regulation that was coming, we were also working on this code of practice, which is the Global South's first code of practice for online harm for the digital intermediaries to follow, was being floated. There was conversation with the Asia Internet Coalition, which is a Singapore-based, body with about 17 digital media intermediaries being represented there, with all the leading social media companies there, except for TikTok. But there were significant delays in the way the digital intermediaries were responding to this code of practice. Now, mind you, this was despite the code of practices being endorsed by the companies in the EU, Australia, and New Zealand. So the Global North Code of Practices was somehow okay for the companies to endorse, but when it came to the Global South, all of these questions were being raised about it. But however, we were also then pushing through, knowing that the government was planning to move this Online Safety Act as well. And a long story short, again, by about May 2023, then President of Sri Lanka, Ranil Wickremesinghe, flew to Singapore to meet with the tech companies to inquire why there was a delay in the digital intermediaries signing on to this code of practice, which we then also had signed up in the other, especially the Global North. And the conversation was fairly a tense, not a tense one. I think it was a fairly difficult one where the tech companies was also sitting together. And then there was a deadline that was set. This was in May 2023, a deadline set for the companies to get back on the code by 31st of July. The moment the 31st July deadline left, there was no sound by the tech companies. And there was really no option, because the government was also then starting to ask us, well, what's happening with this code? And then came by September 15th, 2023, then President gazetted this Online Safety Act. And that's when really the civil society members were also starting to get a bit nervous, because, this was draconian in nature. And I'll leave Ashwini to explain why this was draconian in nature, why it was so problematic. But however, the entire trajectory towards the Online Safety Act being passed was not just on the previous government's need to crush or police FOE, although it has been since used for that. The main reason really were two things. They wanted to actually crush political dissent of the current government. And number two, the unspeakable and in many ways unacceptable delays from the digital media intermediaries not really sign on the dotted line of a self-regulatory mechanism that could have actually arrested most of these issues. And then that's also the preferred way for most of the digital intermediaries, but they were really playing a lot of politics, for the lack of another word. And then, therefore, the real political powers moved to file the Gazette for the Online Safety Act, which was then passed on the 24th of January of 2024.
Thanks, Omar. Ashwini, there has been, of course, a lot of controversy regarding the OSA. In fact, I mean, at least what we've heard and read about, multiple challenges were also filed prior to its enactment. And if you could also explain what that process entails in Sri Lanka, because, for example, in Pakistan, you can only challenge an act once Parliament has enacted it, right? So what that was all about, what were some of the salient features of the OSA, which civil society in particular really took exception to and felt that it would be very draconian in nature?
Thank you, Farieha, and it's great to be here with Omar on this discussion, which is very important and topical right now, because before I answer your questions, I must say it's extremely an important time period in Sri Lanka as well, because the window has opened for public consultation. So it couldn't be more relevant right now to have this discussion, not just for the region, but also within Sri Lanka. And now to answer your question about the Online Safety Act. So essentially, yes, the Online Safety Act, once it was gazetted and it was published, there is a window of opportunity before it is passed at the Parliament to where the public can challenge it on grounds of it violating the fundamental rights under the Constitution. So that was done. There were many petitions that were filed. And then the government responded to it by saying that they will come up with all these amendments, after which will only those amendments, after those amendments are effected to the bill as it then was, will the act be passed. So what had happened was, after that, those petitions were disposed of, and accordingly, the Supreme Court said, yes, we don't need a 2/3 majority because they're going to pass this with these amendments. Of course, it's another, there's another side to it where post the act being passed, there was also a challenge by a few stating that the amendments as promised were not entirely carried out. And that was subject to a review petition. But of course, it was disposed of on a technical ground because it was brought before the same judge. And then the judge said that there's a technical objection to taking that on, because as far as that case was concerned, it was already disposed of. So here they were challenging it, stating that the promised amendments were not carried out, and as a review petition. So that's where that stood. Be it as it may, in 2024, the act was passed. And as you all have been talking about it, and I think it's generated a lot of interest in the region as well, because it is the first in Sri Lanka that looks at intermediary liability, prior to which we've had several other enactments, and those enactments have been used, although they may not use the word online, so to speak, they have been used to regulate content online, to penalize content online. That has been happening. It can be through the ICCPR, it can be through the penal code, it can be through other enactments in the country. But why the Online Safety Act was significant is because it also looked at intermediary liability, that is platform intermediary liability. Previously, if there was an issue relating to taking down content, the government officials or the state, they would approach the internet service providers and ask them to ensure that there is no access. So they would deny access as opposed to having any direct requirements from the platform intermediary. So in that sense, the Online Safety Act generated a lot of interest. But to answer your question, what really happened when it comes to why was there widespread criticism, I can divide it into a couple of areas. The first being the terminology, the vague and wide terminology used in defining offenses. So to give you an example, it talks about false statements, and the definition of false statements is extremely wide. It says where a person knows and with an intention to deceive makes a false statement. Now that statement could be considered as an offense. For that false statement to lead to maybe a riot, or it could lead to a national security issue, or it could lead to public fear in the minds of not just the civil society organizations, but journalists, everyone to defend dissent. because that was something that they were concerned. Also, that it could cause a chilling effect when it comes to the freedom of expression. Because even if it is being argued that provisions will not be used, definitely something that would cause censorship or self-censorship amongst users in the online community. So the first part is, yes, widely worded offenses with vague terminology. Second, to the fact that when it comes to the intermediaries, there were also requirements that the platform intermediaries comply with the codes of practice that are being followed, that are being codified through the Act. And also there was direct liability on the platform intermediaries, including criminal liability for its officials. How this is being enforced is another question. Now, these not only led to pushback from platform intermediaries, but also the business persons within the community, because they felt that, as a small economy, how is this going to be enforced in a country like Sri Lanka? So that was the broadly like the second level. And at the third level, of course, was also relating to how the Online Safety Commission had wide powers. What would be the check and balance for the Online Safety Commission, the regulatory authority established under the Act? So in a nutshell, I think these are some of the areas that were considered problematic and also caused a lot of controversy within the country.
Thanks, Ashwini. Omar, just within a few years, and it is fascinating to see because usually legal processes and reform processes can span many number of years, right? But on the OSA, from its enactment to now a conversation on reform, it's happened just within a couple of years. What has really led to it? And of course, there is the change of government as well, and those who were previously sort of in opposition or, they thought that they would be targeted are now in government. But the civil society sentiment has also been along these lines. And has there been in practice cases that has also bolstered the sentiment that you need reform of the OSA because there has been misuse, and also in terms of keeping the promises or keeping the position consistent on the OSA as it was previously? Because earlier we were hearing this year repeal, now we're hearing more amendment and reform.
So that's correct, Farieha. I think what it was is you're absolutely right. The time period during which the OSA was gazetted and passed with limited consultation was also very shocking for Sri Lankan civil society to start with. But within that time period, it's also important that you engage with the state, because there was some section of civil society that was still trying to engage with the state, despite perhaps knowing that, it may not have all of the amendments that civil society is requiring of this process to be incorporated. But we didn't want the government at the time also to have an opportunity to say that civil society completely ignored us and therefore we can do whatever we want with it. That was point number one. And then when the change in government also happened, right from the beginning, what civil society has been telling this current government is that why are you getting behind? One, defending; two, and then also wanting to implement, number three, a piece of legislation that was brought in fabric to really crush your rights. And that really resonates with this government to a large extent, because, and as Ashwini pointed out as well, and you point out, and many actually who have concerns with online safety laws, FOE concerns, right? Like whether they are going to actually crush and shut the window and FOE. That's pretty important. But we've also actually come to that point, especially with the lackadaisical nature in which digital intermediaries are approaching online safety laws all over, number one, but also on how they're failing to uphold their own community standards and community guidelines to protect its users was becoming very much an issue. So the current government is fairly aware of all of these dynamics. In the amendment process before as well, I was also with some of the other civil society members personally involved, at least in the discussions for the amendments. But it was very clear right from the get-go for us that, not all of what we wanted there is going to get featured. Because Sri Lanka and New Zealand are really the only countries in the world where once legislation is passed, there is really no cancellation of it. The court doesn't get to actually act it anymore. So that we knew what we were actually playing against. So we were fairly nervous as well, trying to go into it. And this is why, even as Ashwini was also pointing out, after the act was passed, even the previous government kept the conversation alive on potential amendments via the ministry. That was actually the subject ministry that filed it. The problem, however, right from the beginning was that why was an Online Safety Act being anchored off the Ministry of Public Security? That really was, the biggest issue that we were also facing, and rightly so. Then people were fearing the draconian nature of it. But number two, also people were, and rightly so, fearing the potential for surveillance, or what do they actually want to do with this? From there, fast forward to now, one thing, even with this executive, that we have to actually admit to is that when there is counsel given to him against the establishment of the Online Safety Commission, he took that on board. And of course, it's not always public knowledge what actually works within it. And I'm also not saying it's ideal that, only some section of civil society is able to give that counsel. But in state engagement, these are political realities that you have to actually grapple with. Some members of civil society actually have better access to certain levers of power. Again, I'm not saying it's ideal, but sometimes, it's almost like a beggars can't be choosers kind of scenario, right? Whoever has access, either if they can actually power through with these recommendations, we do, or we use the other levers that we have at our disposal to be able to kind of do that. So yes, initially what was being floated was repeal in the manifestos, amendments and so on, a revision per se, but now the talk has actually landed on amendments. So there are three processes as of now that's also ongoing to provide amendments to this process via this public consultation. One is led by the United Nations office in Sri Lanka, which has also brought together what is called a community of practice, where multiple civil society and digital rights activists have come together, divided themselves into two groups of a legal working group as well as an advocacy working group, to provide specific amendments, suggested amendments to every clause of the Online Safety Act. This is also going above and beyond what the Supreme Court wanted to act in the initial draft. And number two is that we've also kind of asked the digital intermediaries, whoever has asked us, we've actually told them they probably cannot be part of the civil society submissions on the public consultations, because they've also not upheld their end of the deal, right? Not really acting on this harmful content, letting this harmful content sustain on their platforms is problematic. So that's number two in terms of a submission. Number three, the Global Network Initiative, I think more like a global multi-stakeholder platform, has also made its own recommendations and will file them as will file them as part of this public consultation. So we have input from local actors, we have input from digital intermediaries, and we have input from international actors on what could potentially be a more progressive OSA under these amendments.
Ashwini, what are going to be some of the big asks in terms of the amendments to the OSA? Because that essentially, it seems, will be the process. Has civil society identified some really glaring things where some of the amendments going to ask for complete sort of removal of certain things? Reading down of certain provisions?
Sure. So as Omar just mentioned, we do have a community of practice, and as a part of the substantive legal working group, what we're trying to do is we want to not just look at the Online Safety Act in its current form, but we're also looking at the amendments that were proposed in July 2024, because the call for comments specifically indicate that they say, please give in your comments on the Online Safety Act, plus the July 2024 amendments that were gazetted, but they were never passed because the time period of that government had already come to an end by the time it could be passed. So they've asked for both. And in some respects, for example, some of the offenses, the July 2024 amendments itself call for its repeal. So we do back on that, and we do believe that they should be repealed. But we want to go beyond what is there in the amendments, because several of the amendments from 2024 focused on intermediary liability, including looking at offenses. But we also believe that there are certain other changes that need to be brought in, including, like I mentioned, on the Online Safety Commission. For instance, I can give you an example. The appointment of the Online Safety Commission, for instance, is quite relevant, because the procedure that is enshrined under the current Act, and the 2024 amendments don't speak of that at all, is the fact that the appointment will be made by the President, and it will be subject to an approval by the Constitutional Council. Now, there are two ways to look at it. One, you can say, of course, the approval is so crucial that that will be the check for the appointment by the president, but it could also be interpreted that the approval is a mere formality because it's after the fact, because there is going to be an appointment, and after that, there's going to be an approval by the Constitutional Council. So that's something we definitely want clarity in the wording to state that perhaps upon recommendation of the Constitutional Council, the appointment will be made, which is what we see in several other enactments in the country, for example, including the Right to Information Act. So there are provisions like this that we ask to be amended and also to bring in better clarity. And specifically, we also ask for repeal of some provisions, and some of which that have already been recommended under the July 2024 amendment bill. So this is just to give you a rough idea of what we hope to do in the coming weeks.
Omar, as you go into this process, as civil society goes into this process, what are some of the hopes, of course, with a different setup, one that is fairly conversant in the harms that the OSA poses, but at the same time, of course, there are asks, and like you've also mentioned that intermediaries, and especially foreign intermediaries, the role prior to this, but now that this process is opened up under a different setup, what is it that what are your hopes? What are your recommendations going into this? And on both sides, on part of the government, also foreign intermediaries.
So I think the first biggest challenge, or the hope that we would have as a group, is that all civil society stakeholders who are part of these amendment processes can agree on how we move forward. That's also one, right? Because it's no secret that there can also be very differing views sometimes, and civil society is also made up of a lot of the. There is the entrant civil society members, there is the mid-age civil society members, and you also have the seniors who've actually been in the process of, recommending amendments for various legislations, and then like it to be done only a certain way and would actually not like any alternative ways to do it. So I think our challenge number one, just self-reflecting for our entire process, is that all of the civil society actors who are getting involved with this can agree on the commonalities and then make submissions. That's number one. Number two, really the bigger challenge is that, and Ashwini also alluded to this initially, even when the Online Safety Act was being passed, the business community was not fully aware of the harms of this Online Safety Act can pose until like a month before the passage actually happened. And that was fairly scary because, sometimes the business community can also end up thinking legislative reforms or even reforms to any laws is just something that is not going to affect them. Let civil society and legal and digital rights activists take care of that. That challenge to a larger extent has been fixed now because we do get input from the business community as well on how this actually happens. So that's number two. Another one is around this threat by the digital intermediaries that's very clear in many ways. They say it in many different ways, but I think it just bottles down to these two things, right? Number one, that they will not always agree to all the laws that are actually passed in a country. That there is no jurisdiction to have them comply, right? That's fairly a dangerous one. And number two is also when they actually start threatening a pullout from the country, because if these laws are not going to favor us, we are going to also leave the country. For a case like that, so even in these conversations that has been fairly challenging, we're thinking, how do you actually fight that, right, with a tech company to say, okay, because civil society doesn't have it in their hand to guarantee them a landscape here to stay, but also then comparing it with the Singapore model, right, where, the same tech companies that want to flex muscles with the smaller or rather more developing kind of, global southern states, when it comes to the more developed global southern or smaller states as well, have no issues complying with the government's directives there. But somehow all of these issues start to come up when it's the smaller and the developing type of government. So that's number three. And number four is really our biggest challenge is being able to convince the government that is in power now that what we are trying to do is cooperate with them on a system and share knowledge in a way that we can land a better piece of legislation that can also do the government's credibility good, right? Not to forget, our government also has to go by the United Nations Human Rights Council every year and its universal periodic reviews for the accusations of war-related crimes that was actually committed pre-2019. So every year, the government actually knows this. Really, successive governments have actually known this, right? So they don't want to add to the existing grievances on that front when you also then have another legislation that is being passed. With the government, that is number one. But number two is also making them also realize that we are here to help as civil society, that we have no interest in pulling down an entire government. Just like that, based on this, I mean, we will have to actually be fairly critical with them, but then making them feel like the civil society approach towards them is not really all this bad as they make it out to be, and we are also here to help, and together we can actually come up with a better with a better piece of legislation for everybody.
Ashwini, what is your view on in terms of this process? What ideally should come out of it now that it has been opened?
Thanks. Particularly, I think there's one aspect of the Online Safety Act, that the passage of the Online Safety Act that was widely critiqued, and that was lack of public consultation, widespread public consultation. And now we do have this window for public consultation. So I want to take this opportunity and this platform to advocate that there is actual meaningful public consultation. And that can happen only with the public engaging. And in various research studies, what we have noted is that state has mentioned that, yes, they've opened it for public consultation, but responses have been far and wide, right? We've only not had enough. While they expected to be far and wide, responses have been really very minimal. Maybe 10 or 15 responses are received even after opening it for a month or two. And that should not be the case, because the Online Safety Act is extremely crucial and is something that will impact all in the country. So which is why I hope that many will use this opportunity and actually send in meaningful comments during this window. And the other thing is, from the government's perspective, it's important that these comments are also made public, because what happens is we don't know what comments are taken, what comments are left out, and we also don't know what is the basis or the reasoning behind the government taking a particular view. So it will be a great step towards transparency if we can call for these comments that are being submitted to also be made public, and also the views of the committee that has been appointed to look into it to be made public. So I think these will go a long way, and it's a hope that it will start with the reform process for the Online Safety Act. So that is number one. And the number two aspect of it is, of course, that this passage of the Online Safety Act is we are just beginning with public consultation. We shouldn't rush into passing a legislation and then looking at amendments, and we should now take time, because we already have a legislation in place and now we are amending that. So this process, it should take its course. We should not be in any sort of a hurry and a rush to do it like it was done in the past. So I do hope that in this instance, they will take their time and make sure that there are not just this window, there'll be several other windows where other stakeholders can submit their comments and their views are considered, and then the amendments are made.
There are many lessons for us to learn from what is happening in Sri Lanka right now, the OSA reform process, and how civil society is approaching it. Also because of the Prevention of Electronic Crimes Act in Pakistan, recent amendments that were made, which are similar to the OSA, such as false and fake information. We've seen plenty of misuse. And clearly transparency, public input, and enough time given to that input, and for it to be considered and factored into any reform process is key, as we are hearing from colleagues in Sri Lanka. Omar, Ashwini, thank you so much for joining DawnNews English and for telling us exactly what is happening. And we, of course, will remain invested and look towards Sri Lanka with hope that something fruitful and good for civil society and citizens comes out of this process. That's all that we have on the Digi Pod today.